Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
If you want to understand the absolute bleeding edge future of artificial intelligence and behavioral copyright, you actually don't look at a tech lab in Silicon Valley.
Right, you look at a rotting potato under a couch in 1952.
Which sounds completely absurd.
It does, but, the lineage from a literal root vegetable to a synthetic AI consciousness it's basically a straight, unbroken line of corporate survival.
It really is a masterclass in adaptation.
Oh.
So for today's deep dive, we're exploring this fascinating article titled Past and Present of Mr. Potato Head.
Yeah, it's a great read.
It is. And our mission today is to uncover how this simple, pile of plastic facial features didn't just change how kids play. It actually rewrote the entire rule book for modern marketing.
Oh, absolutely. Marketing, and it completely reshaped overlapping intellectual property laws.
Right. And now it is pioneering an entirely new frontier of AI development.
Yeah.
So for everyone listening, I promise this isn't just a nostalgia trip about a childhood toy you might have buried in your closet.
No, not at all. We are looking at a brand that has managed to survive over 70 years of massive cultural and technological shifts.
Which is incredibly hard to do.
It's nearly impossible. That kind of longevity requires this highly adaptable, often ruthless machinery operating behind the scenes.
Okay, let's unpack this. Because to understand how a piece of plastic eventually becomes this licensed AI pioneer, we have to start at the very beginning.
We have to go back to Brooklyn.
Exactly. A post-war Brooklyn kitchen in the late 1940s where this entire invention was initially seen as highly controversial.
Yeah, we start with George Lerner. He was a Brooklyn toy inventor who was, just observing childhood psychology in its rawest form.
What was he noticing?
Well, he noticed kids taking buttons and sticks and just random household objects, and they were shoving them into real vegetables.
Just playing with whatever they had.
Right, creating these makeshift characters out of fruits and potatoes. He recognized that kids didn't necessarily want a pre-built doll. They wanted the agency to create the face themselves.
So Lerner designs this dedicated set of plastic face parts. We're talking eyes, ears, mouths, hats, and noses.
All with those little sharp pegs on the back.
Yeah, specifically designed to be stuck into a real physical potato to bring it to life. But when he actually pitches this brilliant idea to toy companies in 1952...
He gets a massive wall.
A huge wall. And he pitches it to Henry and Merrill Hassenfeld, the founders of Hassenfeld Brothers.
Which later becomes Hasbro, yeah.
Right. But toy companies were so hesitant because using real food for play during post-war food rationing made manufacturers incredibly uneasy.
Oh, playing with food was a huge cultural taboo at the time. You have to remember the socioeconomic reality of the late 1940s and early 50s.
The country was just emerging from World War II.
Exactly, a period defined by intense rationing. The idea of encouraging children to take perfectly good edible food and use it as a plaything, which inherently meant wasting it, just did not sit well with anyone.
Think about this from a business perspective back then. You're trying to sell a product that requires an external, highly valuable, and recently scarce resource just to function.
It was a huge ask for consumers.
It would be like trying to sell a kid's toy today that only works if you constantly feed it fresh, incredibly expensive printer ink.
That is a great analogy.
Right. Why would a parent buy the plastic bits if they are fundamentally required to keep supplying the expensive essential part from their own limited pantry?
They wouldn't, or at least that was the fear.
So how did Lerner ever convince the Hassenfeld brothers to take on that kind of massive consumer friction?
What's fascinating here is the tension between pure creative play and that socioeconomic reality we just talked about.
Okay.
The Hassenfelds looked past the immediate cultural taboo of the food waste. They actually saw the underlying mechanics of what Lerner had built.
Modularity of it.
Exactly. He wasn't selling a static toy. He was selling infinite customization. But taking the gamble meant they were fundamentally asking parents to sacrifice their own groceries to make a corporate product work.
Which means the traditional avenue for selling toys is completely dead on arrival.
Totally dead.
If Hasbro puts this box of plastic pegs in a catalog or on a store shelf aimed at parents, the parents do the mental math on the food waste and reject it immediately.
Yeah, they couldn't rely on traditional marketing to moms and dads. They needed a completely unprecedented way to sell it.
So in 1952, They do exactly that. They bypass the parents entirely.
It was revolutionary.
Mr. Potato Head becomes the first toy ever to be advertised directly to children on television.
Prior to this moment, toy marketing was always this highly logical appeal to the adult holding the wallet.
Because they're the ones buying it.
Right. Advertisements focused on things like durability, educational value, safety.
Very practical stuff.
But Hasbro utilized this rapidly expanding medium of television to target kids directly with these catchy jingles and cheerful animations.
They just completely abandoned the logic of durability and safety.
Entirely. They sold pure, unadulterated fun, and in doing so, they created consumer demand from the bottom up.
The strategy of Pester Power is officially born.
Oh, yeah.
The kids see the ad, they memorize the jingle, and they just relentlessly beg their parents for the toy until the parents finally cave. Food waste be damned.
And the gamble worked with terrifying efficiency. I mean, in that very first year, they sold over 1 million kits.
1 million kits. That's insane for 1952.
It is. And remember, they were just selling the plastic faces. For over a decade, the consumer had to supply the potato.
Okay, so what does this all mean? We look at the source material, and it details the inevitable parental complaints about rotting vegetables, which eventually forced Hasbro to include a plastic potato body in 1964.
Yeah, the complaints got pretty bad.
Because mechanically, that original 1952 model functioned exactly like a modern tech subscription service.
Yes.
Hasbro just sold you the hardware, right? The plastic eyes and ears at a flat rate. But to keep the toy running, you had to continuously supply your own software.
Ah, the software being mom's produce.
Exactly. And the critical flaw was that the software degraded. It literally rotted under the living room couch.
Yeah, the biological degradation of the software created a truly atrocious user experience for the parents. They were the ones finding moldy potatoes weeks later.
So gross.
By finally providing the plastic body in 1964, Hasbro internalized the entire ecosystem. They transformed the dependent pit into a self-contained unit.
But securing the physical ecosystem is really only half the battle. Because once you have a massively successful self-contained product selling millions of units, the market will inevitably try to clone it.
Oh, competitors were definitely circling.
And the source material outlines how the initial patents on this toy eventually began to expire. So Hasbro had to figure out how to fiercely protect their new cash cow.
The transition they pulled off here is an absolute masterclass in intellectual property law.
Let's get into the legal stuff, because this is wild.
It is. So assuming you understand the basic distinctions between IP protections, what is remarkable here is the strategic layering they use.
It's the layered IP strategy.
Right. Initially, Hasbro relied heavily on patents, and patents protect functional innovation.
The mechanics of it.
Exactly. In the 1950s and 60s, the functional innovation was the interchangeable peg-and-hole mechanic. Because modular toys were pretty rare, that patent gave them a massive competitive moat.
It legally prevented anyone else from manufacturing a toy with those specific physical mechanics.
But the clock is always ticking on a patent. They only give you a temporary monopoly before those mechanics enter the public domain.
So once those patents expire, anyone can legally make a modular peg-and-hole toy.
And Hasbro understood that they couldn't let their flagship product become genericized. So before the patents ran out, they began shifting the defensive weight of the brand onto trademarks and copyrights.
Moving the shield, essentially.
Exactly. Trademarks locked down the specific name, Mr. Potato Head, the distinctive visual look, and the logos.
So even if a competitor built a peg-and-hole vegetable, they couldn't package it in a way that confused the consumer.
Right. But the real pivot is how they utilized copyright. They didn't just protect the plastic shape, they protected the persona.
And this is where the 1995 pop culture boom with Pixar's Toy Story comes in.
Yes. That was a critical legal maneuver, not just a fun movie cameo, by having the character voiced by Don Rickles.
That's a classic voice.
It really was. And then, pushing for his induction into the National Toy Hall of Fame in 2000, Hasbro transformed a physical object into a fully fleshed out character.
That is the crux of this cascading IP strategy. I love this. They brilliantly pivoted from protecting how the toy works with those expiring patents to protecting who the toy is using perpetual copyrights and trademarks.
That's exactly it. You protect the character, not just the plastic.
But even that carefully layered armor can create massive liabilities when culture shifts. Like the recent news highlighted in the source material about dropping the Mr. for a more gender-inclusive Potato Head brand name.
Yeah, a modern rebrand designed to maintain cultural relevance.
But legally, altering a core trademark like that triggers a really precarious domino effect under the rules of commerce.
It does. It's a huge risk.
Here's where it gets really interesting. Because trademark law dictates a very strict use it or lose it mandate in commerce.
Right.
Because Hasbro is actively phasing out the Mr. from their packaging and marketing, their trademark rights to that specific name will expire. They are forcing themselves to refile as just Potato Head.
Which sounds simple, but legally it's not.
No. Think about it like a real estate developer who buys a prime plot of commercial land. Under trademark law, it's as if the developer is legally forced to build a storefront on that land and actively sell goods out of it every single day.
Or they lose the land.
Exactly. If they board up the windows, the government just takes the deed away and lets a competitor build on it.
Yeah.
You cannot simply squat on a trademark. So, I mean, how massive of a legal headache is this for a 70-year-old brand to willingly abandon a piece of its core real estate?
Oh, it requires an incredibly complex legal migration. Your real estate analogy perfectly illustrates the risk of abandonment.
Because someone else could just swoop in.
Theoretically, yes.
Yeah.
If Hasbro isn't actively putting Mr. Potato Head on store shelves, they forfeit the exclusive right to that specific prefix name combination. A competitor could attempt to claim it.
So how do they survive that transition?
The only way Hasbro survives this is because they still hold the ironclad copyrights to the visual sculptural design and the character's media portrayals.
Ah, so the copyright is acting as a bridge.
Exactly. They are using the copyright to shield the brand while they transition the trademark equity. It proves that intellectual property is never static. You can't just patent a toy in 1952 and sit back.
It requires constant, active legal maneuvering.
Decades of it.
But protecting a physical look and a printed name was really the ultimate defensive game for the 20th century.
True.
As we move to the present day in our sources, protecting a physical plastic shape is just no longer enough.
No, because the medium of play is undergoing a fundamental transformation. We are moving from the physical realm into interactive digital spaces.
Right. In 2026, Hasbro launched a brand new division called Sixth Wall.
Which is a fascinating name for it.
It really is. And the entire purpose of this division is licensing AI versions of their legacy characters. They partnered with a voice AI company called 11 Labs to create a fully AI-powered Potato Head.
Complete with a licensed, synthesized voice.
Yes, and Hasbro coined this term behavioral licensing, protecting not just how a character looks, but how it speaks and interacts.
This raises an important question about the very nature of intellectual property in the era of generative AI.
It's completely uncharted territory.
It really is. Hasbro is pioneering this concept of behavioral licensing because they are no longer satisfied with just protecting how a character looks or what its name is on a box.
Right.
They are constructing a legal framework to protect how it dynamically reacts to stimuli and how it interacts with the user in real time. If you synthesize the entire history we've discussed today, you see the ultimate evolution of their corporate strategy.
It's quite the arc.
They moved from protecting a physical plastic peg in the 1950s to protecting a visual and cultural brand in the 1990s to now legally protecting an artificial interactive personality in 2026.
I have to push back a little on the reality of this behavioral licensing, though.
Okay, lay it on me.
Owning a physical mechanism, that makes sense. Owning a logo makes sense.
Mm-hmm.
But a behavior is inherently intangible.
Yeah.
I mean, how do you legally enforce a vibe? It sounds exactly like trying to legally copyright a friend's sarcasm or their specific sense of humor. If I'm an independent software developer and I use an off-the-shelf LLM to program my own distinct AI character that happens to be a grumpy, sarcastic root vegetable.
Which sounds hilarious, by the way.
Thank you. But how does Hasbro legally prove in a court of law that my code is infringing on their potato's specific behavior?
Well, that is the exact legal frontier they are attempting to map out right now, and you're right, it is entirely untested.
Because you can't copyright generic sarcasm.
No, you can't. But Hasbro's argument relies on the matrix of parameters.
The matrix of parameters.
They aren't just copywriting a mood. Through their partnership with 11 Labs, they are locking down a specific synthesized voice model. Then they layer that with highly specific parameterized prompts.
Like what kind of prompts?
Defining the exact frequency of its jokes, its specific vocabulary limits, how it modulates its pitch when a user frustrates it. Yeah. They are arguing that this highly specific mathematical matrix of interactive tendencies, when combined, constitutes a unique, protectable entity that belongs exclusively to them.
That is genuinely staggering to think about. I mean, for everyone listening, Think about the toys sitting in your own closet right now, or the ones you played with as a kid. The physical, static pieces of plastic where you had to do all the heavy lifting.
You were the engine.
Exactly. You had to physically move them, you had to provide the voices, you had to generate the entire imagination loop. Now imagine that exact same piece of plastic looking back at you and speaking.
It changes everything.
It does. Imagine a corporate division parameterizing its responses, owning its artificial personality, and having it dynamically adapt to the way you play with it. The toy is no longer just a vessel for your imagination. It has an imagination of its own.
It completely upends the definition of a toy. George Lerner's 1952 invention was brilliant precisely because it asked the child to bring the imagination to the raw materials. The 2026 AI version brings its own synthesized imagination to the table. Play becomes a two-way street of interaction.
The conversation.
Yes. And through behavioral licensing, Hasbro ensures they own the pavement on that street. They dictate exactly how the character is allowed to respond, regardless of what digital platform or hardware the interaction takes place on.
It really is a phenomenal trajectory to look back on.
Yeah.
I mean, we started in a post-war kitchen where the biggest hurdle was just convincing parents to let their kids stick plastic eyes into a real vegetable during a time of rationing.
Such a humble beginning.
And because they couldn't sell that concept to adults, they bypassed them entirely, airing the first kid-targeted TV ad and rewriting the rules of marketing.
Right.
From there, we traced how they built this cascading fortress of IP law, letting physical patents expire while strengthening trademarks and copyrights, even navigating the legal minefield of dropping that Mr. from their name.
They never stopped adapting.
Never. And finally, we arrived at 2026, where a plastic face has been parameterized into a responsive, synthetic consciousness protected by behavioral licensing. So, what is the ultimate takeaway from all these sources?
I think the defining takeaway for listeners is that longevity is never an accident.
Oh, definitely not.
The next time you see a simple novelty item or a nostalgic children's toy or really any everyday household brand, I urge you to look closer at it. Beneath that playful, seemingly static surface, there is almost always a massive, highly adaptable machinery of marketing innovation and fierce legal strategy working around the clock to keep it culturally and commercially relevant.
It definitely takes a lot of lawyers to keep a potato fresh for 70 years.
That it does.
But as we wrap up this deep dive, I want to leave you, the listener, with one final, lingering question to mull over on your own. We've spent this time exploring how corporate behavioral licensing is attempting to build a legal framework allowing a company to own how a synthetic AI character speaks, jokes, and interacts.
The new frontier.
Right. But if that legal framework actually holds up in court, if you can successfully parameterize and legally own a conversational style, how long will it be before human celebrities or even everyday people attempt to legally trademark our own behavioral quirks?
Oh, that is a wild thought.
If a corporation can copyright the conversational style of a plastic toy to prevent it from being copied, how long until we try to copyright our own personalities and conversational styles to prevent AI from mimicking us? When a potato can legally own its own behavior, how do we protect ours? Something to think about. Until next time.